me begin on this question of the O&C payments. Mr. Abbey, I mean, these are extraordinarily important to rural Oregon. They go to counties that are very hard hit, where unemployment is just in the stratosphere. They just feel that in this economy, they feel like they've been hit by a wrecking ball. And I want to go through with you some of the errors that the agency has made with respect to calculating these payments and try to figure out how this happened and then what we're going to do to turn it around. Now, I learned recently that the Bureau of Land Management revised its estimates of county payments to be made to Oregon's O&C counties for fiscal year 2011. And the revised estimate revealed a significant error that the Bureau of Land Management committed, with the result that these counties are going to receive approximately $11.6 million less than they originally planned and budgeted for. The amount of the reduced payment varies by counties, but for some of the counties, it results in millions of dollars. Now, my understanding from a call which BLM and Forest Service employees did with my staff and others in our congressional delegation is that the Bureau of Land Management learned of the errors in March when the Forest Service was revising its estimates for the 2011 payments. The Forest Service then put their revised estimates for the Forest Service lands on their website. The Bureau of Land Management did not publicly post those numbers. Instead, the Bureau of Land Management waited until June to let the counties know of this error. That was after the counties had completed their budgets for the coming fiscal year. So the changed information means that they've now got to go through a lengthy process to publicly amend the budgets, and the counties in these tough times are going to have to scour their budgets again, trying to figure out how to make deeper cuts. Now, I wrote to you on July 20th asking for these revised estimates and an explanation about the calculations. And I haven't gotten those revised estimates from the agency, although the counties have shared with me the information that they have with respect to what BLM provided to them. I also didn't get a response to my letter. Mr. Abbey, this is just completely unacceptable. This is so important to my state. As you know, I wrote the county payments legislation with Senator Craig, wrote the reauthorization. This is a matter of great importance to Oregon. And why don't we start by having you explain to me how the error occurred. One, why the counties weren't notified until months after the error was discovered, and why they didn't get this information in a timely way to factor it into their budgets.
Well, let me do my best. Senator Wyden, I'm fortunate to work with 10,000 of the most dedicated public servants that you'd find anywhere in all of government. Unfortunately, mistakes sometimes are made. In December of 2010, when we were putting together the final information for the President's, or 2011, when we were putting together the information for the President's 2012 budget request, there was a mistake in the calculation for the O&C County payments. That mistake was discovered in January or February of 2011, in time for us to correct that mistake and incorporate the correct estimates as part of the President's 2012 budget request, which was published and disseminated to the members of the public in March of 2011. The mistake was compounded, unfortunately, by us not communicating the corrected draft estimates to the counties. And therefore, rather than reviewing the President's budget request, they were dependent upon the information that had been shared to them from the Bureau of Land Management from our earlier calculations as they worked to pass a budget for their counties for this coming fiscal year. What I have done is to look into the situation to see how the calculations were corrected, when they were corrected, why the communications had not been, or why the information had not been communicated more timely to the O&C counties. I've got the information. I will include all that information as part of my response to your letter.
So when will I get that?
Well, I just reviewed a draft of it yesterday afternoon, so you should get it within the next couple of days.
Okay. What is going to be done to try to help the counties get through this? I mean, this is going to be very, very hard on them right now in this kind of budget cycle. What can you tell them about how they ought to get through dealing with their budgets, given the fact that a mistake was made by the federal, government? As you know, this program exists because, the federal government owns most of our land. I mean, this is not like much of the United States where you can sell a piece of private property and taxes are paid as a result of the sale, and you can go about your business and providing, services. We are in this situation because the federal government owns most of our lands. So we don't have many options. What can you tell our counties they ought to do to try to get through this budget season?
Well, I wish I had those answers as well. I do know that the calculations are based upon law. The amount of money that will be distributed to the ONC counties through the Bureau of Land Management will be approximately $40 million, a little over $40 million. As part of our letter, an attachment to our response to your letter will include what we estimate to be the breakdown by county. Again, that information will be shared with the county officials, and to the degree that we can work with them to alleviate or mitigate the effects of the lost revenue or the lost distribution, we will do so. But I'm not sure we have a lot of options.
Well, I'm sure they're going to have some ideas for how to mitigate some of the consequences here, because they feel very strongly about this. And to me, your point about the dedication of the employees of the Bureau of Land Management is well taken. There's no question about that. We deal with them constantly, and they do a very good job. What I think has angered people in my part of the world is y'all knew about it months ago. It wasn't communicated. We're still trying to excavate the facts here at this subcommittee, and had it been communicated in a timely kind of way, that would have been the best way to kind of mitigate some of the consequences. So I'm looking forward to getting your letter, and I'm sure that the ONC counties will have some suggestions about how to mitigate this, because this has really made for some very difficult times, as if they didn't have already enough to deal with in communities that have unemployment, in our view, of well upwards of 15%. I'm going to have some other questions, but I'm over my time. I want to let Senator Risch ask what he desires. Let's go to S1144, the soda ash royalty reduction legislation. Mr. Abbey, your testimony said that the bill will make the statutory requirement that the Secretary provide Congress with a recommendation on continuing royalty relief a moot issue. That is not the intent and the sponsors. Over a year ago, Senator Barrasso and three of my colleagues, Senator Enzi, Senator Merkley, and Senator Feinstein, and I wrote to the Secretary asking that the Department expedite the soda ash royalty study required by the Soda Ash Royalty Reduction Act from 2006, so that Congress would have the information in a timely way to gauge whether or not royalty relief ought to be extended. And I spoke to you earlier this year about the importance of the report and the importance of getting an understanding of the impact of foreign producers, particularly China, on the market. So now we are just a few months from the October deadline, and there is still not a report. My understanding is that if Congress takes no further action, soda ash royalties automatically would increase to the higher levels. So here we're dealing with a situation where the clock is ticking. There is no report, and let's start with when the report is going to get finished.
Well, again, Mr. Chairman, we anticipate delivering that report to members of the Congress in September.
Okay. Now, foreign competitors, particularly, again, China, appear to be subsidizing their own production of soda ash. In April of 2009, China began to offer soda ash exporters a 9% rebate on their value-added tax, a subsidy which has continued. At that time, a bipartisan group of senators and representatives, including Senator Barrasso, wrote to Ron Kirk, our U.S. Trade Representative, asking him to take action on what we believe is a blatant effort to subsidize Chinese soda ash exports. What is the department's estimate of the impact of foreign subsidies on the ability of the soda ash industry, our soda ash industry, to compete in the world market?
Well, again, we'll provide some of that information in the report, but in the meantime, I will say this, that the domestic industry in the United States does have some advantages over the synthetic soda ash that's being developed in some of the foreign countries. It is cheaper to use natural soda ash that comes mainly from the public lands here in the United States, and so therefore it does make U.S. exports more competitive in the world market. Again, if you look at the current reductions in royalty, no doubt that any reduction in costs, including royalty payments, does enhance our domestic industry's position in the world market.
One last question on the soda ash issue. I think it's certainly obvious to Americans now that moving legislation through the Congress is not exactly a quick process. And we wanted to hold this hearing today on legislation because the clock is running, and it was my judgment we just couldn't wait any longer for the department to come forward with a recommendation on extending the royalty relief for soda industry. I just felt we had to get going. We've been trying for some time to move the process along. We haven't been able to get this report. It's my desire to keep working with you and the Secretary, but I'm beginning to have questions about whether this crucial work is going to get done before October. So it is also my understanding that the Mineral Leasing Act provides the Secretary discretion to set the royalty rate for soda ash at 2%, and that it gives the Secretary the discretion to provide case-by-case reductions for the royalties. My question then is, to wrap up this matter, if the department continues to take its time to get us this report, and then the Congress comes back and it's just not possible to get this legislation passed before October, what administrative action could the department take to provide interim relief given the importance of soda ash production to our economy and jobs? This is a jobs issue.
Yes.
I mean, we try on this subcommittee to constantly look at energy as one of the key issues with respect to employment. The energy sector feeds the job sector of this country, and I outlined some of the provisions that we believe gives the Secretary some discretion here, and tell us what administrative action the department could take to provide, as I've suggested, at least some interim relief in an area that relates directly to employment of our constituents.
Well, Mr. Chairman, there are provisions in our regulations that allow for leaseholders to apply for royalty rate relief, but they must meet certain criteria, and there's 3 criteria that we use in reviewing such requests. First, the criteria is in the interest of conservation. If there's a reason why the industry decides to do something, or a particular company decides to do something, protect the natural resources, and they come in to either shut down operations during for some wildlife reason or some other reasons, then certainly we will take that in consideration in looking at a royalty relief. A second criteria that we use is will encourage the greatest ultimate recovery of the mineral resource itself. And then the third criteria that we use to review these proposals is it necessary to either promote the development of the mineral resource or because the company cannot successfully operate the lease under the existing terms. So those are the 3 criteria that we use to review the requests that may come in from the industry when they're seeking a royalty rate relief. We have granted such relief in the past in some cases for coal and some of the other leases that we have on public lands. We would certainly look at requests from the soda ash industry.
So I want to make sure again, because this has such impact on our economy. It is pivotal right now that we move quickly. what else do they need to do to be able to get this interim relief? I mean, I think the way I'd characterize it, there are jobs on the line. You know, soda ash for my constituents is a pivotal aspect of the economy, and we just do not want to lose more employment. What else needs to be done?
Well, again, as you indicated in your own comments, the royalty relief is already set for 2% up until the time that the 2006 Act expires, and that's in October. At that point in time, prior to October, if this bill has not been passed by Congress, then certainly the companies can apply following the regulations that we have in place for royalty relief. We would take their applications, we would take their requests, we would review it, and we will make a decisions.
On the basis of what you know now, are they positioned to be able to get administrative relief?
Some companies may provide appropriate justification that we would grant such a relief, others may not. We would have to look at it on a case-by-case basis.
I'm going to have some other questions on this, but Senator Risch, I know, is very concerned about this as well, and I want to let him ask his question.
Mr. Abbey, I hear what you're saying about this list of standards that you have. Who put together that list of standards?
The Bureau of Land Management put it together several years back. It's part of our regulations.
Don't you think maybe it's time to review that? It seems to me that's a pretty narrow list of things, particularly in light of what Senator Wyden has said here about how important it is in the economy and other things like that. I mean, this issue is broader than just the narrow scope, it seems to me, that those standards are, not the least of which is the economy and the position we're in the economy. You know, these resources belong to the people of the United States, and the people of the United States need relief right now, and since it belongs to them, we ought to see if we can't use it to create jobs, as suggested by Senator Wyden. So I would urge that, and I don't expect you to resolve this right here, sitting here, but I'd urge you to think about this and see if there is in some way you can review those standards and not simply accept the fact that these were written in stone some many years ago and that they're still there.
Okay.
We'll wrap this up with just one last point. I mean, soda ash is an industrial mineral, and it's important to folks in my state, it's important to folks in Wyoming, it's important throughout the West, and because of its relationship with our economy, we have got to work together on this, get it right, and make sure we don't lose those jobs. Can I leave this subject knowing that you're committed to working with us and the senators from Wyoming so we get this done?
You bet.
Okay. One last question, if I might, on federal geothermal leasing issues. Geothermal resources play an enormously important role in providing energy for our country. Federal geothermal leases generated more than 4,600 gigawatts of electrical power in 2010. The bill that I've introduced is intended to help expand the development of proven geothermal resources by making small tracts adjoining proven resources available on a non-competitive basis. Do you agree that this approach can help to accelerate the development of these resources?
I do. We think it's a good approach.
All right. One last question on this with respect to fair market value. I believe it's very important that the public receive fair market value for public resources. The bill specifically requires the department to obtain fair market value for adjacent parcels, even if they're not competitively leased. The bill also requires lessees to pay the higher annual rental payments for the adjacent parcels as if they were obtained competitively, though they're not. Any suggestions or modifications on this, Mr. Abbey, that could make sure that the government and the fair compensation issue are addressed?
We do have a recommendation, and again, one of our concerns with the bill as currently written, it sets a minimum price on how much the Secretary may determine the fair market value to be. We believe that this provision is not necessary because the Secretary of Interior is also authorized under the provisions of this bill to use the regulatory process to actually establish fair market values for these leases. So we believe that certain provision or that specific provision is not necessary.